I just did it back.
Susan, will you turn the recording back on?
And Ben Rasmussen was the
He's
agency
the
records officer.
respondent, he's the record officer.
Okay, call the meeting back to order. So the next item on the agenda is it's hearing 2020. Thank you.
But from the emails here, it appears that they are using private phones in a work capacity.
Okay, so I have a question. So I don't understand. Why do you think they're using their phones?
Well, it says right here in this email that I got as part of the bundle that he gave me, it says that the messages related to work on private phones. Thank goodness she didn't ask for these before the date of November 1st, and that Ben fully expects that I will be
Okay,
appealing this.
wait. Could you just, I don't know how much you're
Quoting.
summarizing and how much you're quoting.
That was a direct quote, but I can read it one more time
Okay.
word for word.
Yeah, and a little slower.
Okay. FYI, this is responsive to my request. And they're writing this to somebody on the state school board staff. I don't know all the people. FYI, I have some responsive from you that fall into this category. Luckily, they are all dated before November 1st. So non-responsive to my request. But USBE doesn't pay for my phone anymore for this very reason. Ben fully expects she will appeal, meaning me, and messages related to work on our private phones will probably have to be included.
Okay, and this is an email you got through a request?
This is the one that they sent to me as part of the request. It just happened to be, I don't know, slid in or missed. But again, I have a concern when I'm seeing this. And then so many things that are saying we're just withholding all this information. I just need to find a way to verify that what I'm being given is the actual responsive, you know, to the documents itself. And my experience has shown me over time that it's very hit and miss on who they are getting text messages from and not with certain.
Okay,
State board
help me
members.
out on this. I'm just trying to think about this. How would the records manager, what do you want the records manager to do to get that text from that private phone? How do you imagine that that's going to occur?
Well, I've been told that.
No, if this was a perfect world, is what I'm asking. How would that happen?
Well, the perfect world would be that people would be honest, and when they're asked if there's a responsive record, they would actually give it. I commend those people who do that. Right here is proof that he sent to me that there are messages on their private phones used for work. So he should go up and ask. I mean, I know that at certain higher levels, they actually go and take the phone of the person and the grandma person runs the report themselves personally. I mean, there's ways to do it, but what I'm saying, what really flagged me wasn't when I'm missing the email to the state school board. Like, why don't I have a copy of you asking them what changed in the email to the state school board members versus the other agencies you sent that were all exactly the same that's being withheld from me?
Okay.
So now we'll go to the respondent. Is it Quisenberry?
It's Questenberry, Brian Questenberry. And before I kind of get into my presentation and I'd like to share my screen, I'd like to respond just briefly here to the two different emails that have been, I guess, quoted or represented. I think Mr. Rasmussen's got, since one of them is purportedly from him, I think he was going to respond to that. And then after he finishes, I'll jump in and I will not be taking 20 minutes.
Thank you.
I was just going to say this email that she's been referring to, I believe is between an employee of our agency and an employee of, I think it may have been an employee of SITLA, the Trust Lands Administration at the time. So now working for the legislature or some a different agency at this point, but it was an email outside the agency. That was what it's produced. I'm an attorney for the board. My communications with the board, our attorney-client privileged, has been our interpretation. And so any communications that I would have had with the board regarding responding to Ms. Orton's request would not have been produced because of that.
Are there any further questions on this specific issue here that has been raised? If not, then I'll just jump into a few comments that I have.
Please go ahead.
Okay, I'm going to share my screen. Let's see. Okay, that's it. Okay, I want to begin here. Can you see that okay, or do you want me to enlarge it? I'll just enlarge it. Can you see that okay?
That's
Yeah.
good.
Okay. I want to first read specifically her two grandma requests. They're kind of, they relate to each other and they're less than a week apart, just so you can see the incredible breadth and scope of the personal records that she is requesting. This is a letter sent to her from me denying initially these two requests. So this is verbatim from her grandma request. Please send any and every record, email, text, document, or communication sent by or received from any of the following: Sydney Dixon, any USBE board member, there's 15 of them, or Access Committee member, or any Utah Board of Education staff member. By the way, there's almost 400 staff members that work for the board. So this would be covering close to 400 people, this specific reference, including Questenberry, that's me. I'm the board's attorney. And so evidently she feels that there's no such thing as an attorney-client privilege that would cover my correspondence with either staff or the board. But that's another issue. And then also that contain, here are the words. So from all these 400 plus people, she wants text or emails essentially that have these words: advisory, committee, public meeting, 5001 Orton, Title 52, AIM, minutes, and so on. And then she followed that up with almost identical requests. See, it references Sid Dixon, board members, the almost 400 staff members that contain any of the words Orton or Orton. So she wants to know basically what people are saying about her in their private communications. The breadth here is just staggering of what she wants. And she's not specifically asking for communications on a board phone or on a board email address, but she wants private emails and private text messages from these staff members, these board members, these access committee members to other third parties. That's private text and private emails, and wants my text and my private emails. Now, we have private lives where we share opinions with family members, opinions with friends regarding work. For example, I go to monthly board meetings and people come up and give public comment, including Orton herself, and I sit there and I listen. What if I, at the end of her comment, I text my wife and I say, "You're never going to believe what I just heard. Orton said this, this, or that." So I now have to produce that personal private communication from my private phone, private text message. That's what this grandma request is requesting. Another example, a staff member attends an access committee meeting. They're invited there to speak. And afterwards, that same staff member texts or emails a friend and says, "Friend, I just had an interesting time at access committee, and here's what was shared. Here's what I said." That personal communication from a staff member to a friend would be covered under this grandma request. So let's be clear of the scope of these two grandma requests. They're extremely broad, extremely intrusive into the private communications that we have on our private devices with our friends and family and spouses. Now I want to read through what a little bit more here of this document. So here's the scope of her two verbatim grandma requests. So they were denied, and here's what was explained. This is what Was that USBE denies. So this is the first grammar request, and here's almost identical denial of the second grammar request. The first one, USBE denies access to board member employee text sent on personal phones. That's exactly what I'm saying right now. Not paid by the State Board of Education. These are not prepared, owned, received, or retained by USBE, and therefore not subject to grandma. Here's specifically where this language, prepared, owned, received, it's coming from, right here. So this is a statute you're familiar with, 63G 2301 is the definitions statute. And this is where that verbiage comes from. It defines what a record is. If a document fits within this record, then it's subject to grandma. If a document does not fit within this record definition, it is not subject to grandma. So record means electronic data that is prepared, owned, received, or retained by a government entity. So the government entity here is USBE, State Board of Education. So the State Board of Education prepares, presumably a staff member, prepares, or the government agency owns or receives or retains electronic data, then it would fit within this record request. Conversely, if it's not prepared, owned, received, or retained by the government, it doesn't fit. And it goes to the point that was just raised is how exactly do you require a staff, one of 400 staff people, to produce their private and personal text messages in response to this? There's no mechanism. It's not in the statute. There's no law. Are we supposed to discipline the employee if they don't produce something? Fire the employee if they don't produce it? There's no practical means to enforce the interpretation that Orton has here on these grandma statutes. Now, so there's the statute that I just read. Additionally, there's these 5 bullet points. Again, they're almost identical to the 5 bullet points down here. And these were categories of documents that were withheld because they were subject to attorney-client privilege, and there's where that exemption is found. They contain or discuss protected drafts. They contain a discussion of licensing applications. Some of them, well, 56 of them, they also contain student records protected under FERPA. They contain private contact information and personal recommendations. So this group of 56 emails was intentionally, specifically withheld. Similarly, another group of 50 was withheld for the same reasons. Okay, and that's fine. And here is what her response was. As you and Ben are both aware, text sent on personal phones, even if they are not prepared. So again, this is Orton speaking right here. I'm quoting from her her response. She says they are subject to grandma searches when the public servant is using them for public business. No citation of legal authority there. Further, I do not believe that all of the emails withheld are subject to those exceptions, attorney-client, protected drafts. What she's saying here is, Ben Rasmussen, I don't believe you. You're lying to me. That's exactly what is saying here. No proof, no basis for this other than I just don't believe you. You work for the government, so I'm not going to believe you. And again, today, we need some other than suspicion or a hunch. We need some proof here that business is being conducted intentionally by staff, by board members, by access members, going behind Orton's back. We don't have that. So you've got the legal problem is that statute I just read is a significant hurdle here that applies. You've got the practical problem that we've talked about in going out and trying to get staff members to produce or provide, or even board members to produce or provide, or access members to produce or provide their own personal text message and emails, which you cannot do. And additionally, just recently, in a recently concluded legislative session, there was a bill that was run to expand grandma to cover some of these additional documents. It failed. So if the legislature intended for an expansive view of it to cover some of these personal private emails and text messages, it didn't pass. It failed. Absent here, again, is evidence that the staff or the board or the members are texting. There's some cabal here going on amongst staff members and board members, a conspiracy to hide documents. It's not here. it does not exist. Access members are not texting and emailing their friends about Orton personally. And if they did, they can do that. It's still not subject to grandma. Staff are not texting or emailing about Orton personally, which they could otherwise do. We just have Orton's conspiracy theories that are supported by suspicion here regarding these documents that she wants. And that makes them, these grandma requests, a fishing expedition. And that's what happens when you don't know what's out there, but you just want to ask and grab and see what you can get. The end game here is to dox staff, to dox members of Access, to dox board members. Here's how this plays out is, let's say she gets a personal text message from a staffer that references her and disparages her, says something unkind or unpleasant. Then that email goes on her social media feed, goes on a whatever platform that she has to her people to show how nefarious that USB staff members and people are being about her. And they get identified, email address, maybe other information. That's where this goes. And that's not the intent of the law, to invade into personal and private communications by hundreds of employees of the board, including board members and others. And so based on that, we would ask that this committee deny this appeal as indicated in the matters that we've submitted in writing and also here on oral argument. Thank you.
Thank you. Any questions from the committee? Hearing none, you have 5 minutes.
Yeah, no problem. I don't need that much. I do have a question regarding Ben Rasmussen's role. He is a grammar records officer who has been trained as a lawyer, but he's not acting in a capacity of a lawyer as a grammar records officer. I want to know if I'm understanding correctly that anything he sends is now attorney-client privilege to anyone on the USB. Is that correct?
The answer is that he is a licensed attorney, and in that capacity as the board's records officer represents in these matters the board. So it's protected. He's a lawyer, licensed lawyer. The board pays for his license, his fees, pays for his legal education. So it's protected.
Thank you for that clarification.
I would also like to add, I want to remind you, our job here is to make sure the records have been classified correctly. So we don't have to impugn Mr. Rasmussen. We can look at the records for you and say, yes, that record was private communication. So if you want us to do that, we can do that. But if you want us to investigate Mr. Rasmussen, that's not our job. Okay?
That's not what I'm asking. In fact, originally what I requested was to see if they were properly classified. It looks like there's only 56 emails. And by the way, I know Mr. Quisenberry was a little bit excited in his response, but this request was only a little bit over a week. It's not like I'm asking for 5 years worth of data for this time. A very specific time about a very substantial issue, open public's record request that I had met with the state auditor on, I had talked to the Attorney General's office on, and we needed those communications in whatever capacity that was, because a lot of those open record meetings we were looking at weren't directly about the board. They were about staff members on the background. It had to be necessarily broad for that subject and very timely in that little over a week period, so I could respond to those other things. Just to let you know, I'm not out here doing a fishing thing. I'm actually just trying to make sure that our open public meetings request that I was asked to give a report to the Attorney General's office on had enough and sufficient information. And because it was a response to my comment at the public school board meeting, that's why I asked about communications with my name. This is not, I just don't want you to think I'm frivolously going around trying to do conspiracy theories about cabals.
So what exactly was the topic?
There's an access committee that meets behind the scenes made up of volunteers that were making decisions. And the question was, should that become an open public meeting? Because at the time that I spoke, they met all 5 criteria. Since then, the State Board of Education changed some things to make it so that they couldn't be public. But that was the issue at the present in November when this happened.
Okay.
Yeah, thank you.
Can I ask a question? Did you say there were 56
records?
That's what it said on the.
It's
on the
right here.
invitation.
There's two.
Yes, and we've submitted those through Rebecca.
I didn't miss that.
So,
thank
yeah,
you.
we can look at that.
And just so I'm clear, Ben Rasmussen, any communication from him ever is protected?
No, that's what I said. That's our job,
Yeah.
is to look at any records and make sure that there might be some that are not attorney-client
I'm
privilege.
just trying to look in the
But
future.
that's-
Do I always have to come here
Yes,
for anything from Ben Rasmussen?
well, as long as anything that they categorize as attorney-client privilege.
That just helps in the future. Thank you.
Yeah. Right? Isn't that our job?
That's what she's asked us to do.
Yeah.
Is that the, and
Yeah, and I will just say at this point, my biggest questions have been answered, so I am fine to waive the 56 email reviews at this point. I'm fine to do it. I think, like I said, the structure, and I did want you to know, again, that discussion about private versus personal, I just think that it's needed to be brought to your attention to see what's going on. And again, one last comment, like I said, I'm happy to waive that. I don't need to see those at this point. I am concerned that certain board members have been targeted to get personal and private emails requested from them and others have not. I'm just asking in the future, this is almost like me making a public comment at this point, to just make sure there's consistency across the Utah State School Board on who and how is treated.
See, that's not our job.
Okay, well,
We have no authority.
well, you'll see when it comes. You'll know what I'm talking about. Thank you.
Okay.
Mr. Quisenberry?
I have nothing further. Thank you.
Thank you. So we'll move to deliberation.
Okay.
Public comment?
Public comment,
Yes.
please, 1 minute.
Hi, I'm Katie Ratzlaff again. To answer your question, Maureen Cornwall, my husband is a forensic investigator. So you were wondering about how to obtain emails off of personal phones. All you would have to do is simply plug it into a
Oh,
Celebrate.
no, I know,
Oh, okay,
I know
okay.
the technicalities.
okay.
I'm just wondering how you get something that's private. I mean, we do have this is a free country.
Uh-huh.
Do you send the policeman to my house and say, give me your phone? That's what I'm
Oh,
asking.
okay, so I misunderstood your question.
Yeah.
Okay.
Yeah.
Second comment, with all due
I
respect.
may have gray hair, but I understand technology.
It's relatively easy, but yeah, I am personally offended by the comment that this would be used to dox somebody. Because I think gamma requests were set up for just obtaining public information. Now, I think what Mrs. Orton is worried about was the statement that said, my phone is not paid for anymore. I think the word here, anymore, is what needs to be considered. I mean, is this purposeful that they agreed to no longer pay for her phone so that in the future, when grandma requests were made, her text would not be under consideration, her, I don't know who this is
Again,
referring
this
to.
is
but
not our purview. We don't have the power.
Who would we go? Who would
The
we go to?
legislature.
So I am addressing you then on this.
No,
question.
that's not the legislature. The legislature of
Okay.
the Capitol.
Okay, thank you.
Yeah.
Okay, any other discussion?
I do a clarifying question as for Mr. Quisenberry. Just want to make sure, is it the position of the State Board of Education that someone who is doing grammar requests, who is a licensed attorney, but is not an assistant attorney general, is acting in the capacity as legal counsel for the State Board of Education?
If that individual, such as Mr. Rasmussen here, is appointed and that's his job duty specifically for grandma to respond to grandma requests and handle grandma requests, then yes. That's not, I haven't been given that duty other than to attend these appeals and represent the board. But as far as collecting and requesting from staff members and board members, that's all Ben Rasmussen. That's his job.
Okay. Thanks.
Okay, move to deliberation.
Well, this,
Well,
another difficult one.
Yeah.
So the issue of, and it came up in the House bill that did not pass. The issue continues up there with regards to private devices like cell phones, where you're talking about something that's public business, even if it's on your private phone, if it's public business, it is theoretically admissible or certainly obtainable. That can be something that can be ordered. Now, HB 57 would have made that a non-question. It's still not been passed, so it's still a question that's out there. I've talked many times in my years on this committee about the bill that came before the legislature years ago about this very thing, where public officials were saying, I don't want my phone to be accessible. I want to be, you can come after what's on my private phone, even if I'm sitting on the House floor talking to somebody else on their private phone on the House floor. But we're on state law. That's a weak argument. If it's business is business, but nevertheless, private phones are private phones. So it's an ongoing debate. And we're not gonna be able to settle it here. And it's not our rule to settle it anyway. So I don't know.
I think we do have, because we do have that Allen decision.
Yeah.
And we actually didn't say that the decision wasn't to make them go get the email. It was that we had no evidence that there was anything on those, the private phones.
But didn't we in that order request that the commissioner look for any records
Right.
on his personal phone that were responsive to the request?
Remember the
But the important difference that I want to point out here is there's a couple of important things. One is they still have failed to pass that bill in the
Yeah,
legislature. Secondly, we were talking about two elected officials. And we knew the two people
We're in the meeting.
that were in the meeting and they saw the phones. And so they had a specific case where they were asked. In this situation, especially to ask for all the employee texts, it would seem that you would want to at least require that of elected people. The Board of Education is appointed by the government, by the governor. So there's another difference, not an elected person, but an appointed person. The access people are simply an advisory board that meets and discusses and then the employees, if there are, what do you say, how many employees? 400?
Almost 400. And ma'am, the board is elected. All 15 members are elected. They're not appointed by anyone.
Oh, okay.
So they have to know.
Oh, okay. So they are elected. So that's an issue, but we still have the bill that didn't pass. But the employees, most of them are not decision makers at the level that in this specific issue would not have been at the meeting, would not have heard the comment. So again, that's another reason why it looks more like a fishing expedition. And it's not like the Allen case where we had two people, we saw their phones, we knew that there was something going on.
Yeah.
And we just don't have that in this case.
So if I understand the presentation and the material correctly, they did the search. They've come up with.
No, but they didn't do, no, if you read this, it starts out and says, USBE's, the first one here, USB denies access to the board members' employee texts.
Yes.
So the only ones were, that they found were in their.
How many
We
records?
searched the USB email system. We didn't search any personal phones or texts.
Yeah, so they did not search the phones.
And how many records have been provided?
There were a lot. I don't remember the
Okay.
exact number offhand.
So with the two categories, the two requests, there's a total of 106 records that have been withheld for the reasons listed. Is the
Right.
committee clear on that? Tom, did that make sense?
I'm sorry, I'm trying to find something here that I'm.
That there are
Oh, there it
56
is.
There it is, yeah.
records in one group and 50 in another that were withheld.
Right.
One of those reasons is
Okay.
attorney-client privilege.
All right, so
But she has said we don't need to
I don't
check
need to
that.
go through those. I'm okay with this. My bigger overlying questions have been answered through this.
Okay,
So I'm okay to waive that.
so you're no longer asking the committee to review those records.
At this point, I think I'm okay to.
The
just-
56 or the 50?
Either one. I can actually waive the whole thing. Like I said, I was more interested in the information and the process. And the information that I have was, is good, but I do still believe there's a reason they're withholding that one from the state board that you might want to look at. But I'm okay to not come here without that. I mean, I don't need the document when I leave.
So what I'm hearing, that's a withdrawal.
Yeah, kind of.
Yep.
Yeah. I mean, if she doesn't want the records, we don't have to worry about making a decision to release them.
Now, are you clear on that? So
Yeah,
you're
I'm
not
very clear.
asking us to make any
I will
decisions
withdraw.
about private emails and texts?
Yeah, thank you.
Okay,
Do we require a motion of any kind? Or is it just a withdrawal, noted as a withdrawal?
You Make it formal with the motion, say we accept or.
So
It's up to
let's
you.
do this. I make a motion that this appeal at the request of the petitioner has been withdrawn and we, as a committee, no longer need to make a ruling.
Just dismiss the case.
Just dismiss the case.
Okay, we have a motion from Tom to dismiss the case. A second?
Second.
Second from Nova. I don't know why I looked right at you. We'll take a roll call vote or any discussion to the motion. We'll take a roll call vote. Mark? Aye. Tom? Aye. Marie?
aye.
I vote aye.
Aye.
No, Nova is an aye. It's unanimous. So thank you.
Thank you so much.
Thank you. Thanks, guys.
Thank you.
A committee, the next item on the agenda is Board of Education again. Are we ready for lunch or? Okay.
Yeah.
Is it here?
It's not like that.
Mine's here under the table.
Did you bring your
I
own?
did.
What?
No, but they do feed us.
I know they do, I know.
You have both parties for the next one. It's the continuance.
We just don't want to lose Nova.
I don't.
If I can just interject, I think this next item is really brief. There was, I think, 4 emails that we submitted in camera for the committee to review last month. And then, and I think you were gonna look at whether those should be disclosed to Mr. Bejarano or not. And that was really the only issue.
And it's just a continuance.
Yeah, we
Let's
should
just-
just
let's
vote
do
on
the
that. That was
continuance.
those 4
Document that we couldn't
documents.
see during the meeting,
Oh,
so. we're looking at
yeah.
between-
I can do-
Remember,
I
and
can
just
do
one
it.
of them we couldn't read,
I won't pass out.
Yeah,
but
that's
now we
right.
read.
Do you want, I have candy.
No, I'm good, I'm good, I'm good.
This should be brief.
Yeah.
So for this next thing, I'm a witness.
Okay.
So I don't understand the issue with the one document. What are we?
So who's the
There was one that
petitioner?
couldn't be
So,
open, and so you.
Jonathan Bijorano is the petitioner. We had presentations last month.
Right, it was the in-camera.
Oh, right, so we don't
So
need
you're-
any,
You're in deliberation at this point on this case.
yeah. Sophie, did you hear that? We're in deliberation, so we're not taking comments at this point.
Oh, okay.
Okay. So we're gonna go ahead with the Bejarano versus Board of Education. It's a continuance.
Right.
Back in camera on that?
Yeah, we need to go, I move that we go into in camera.
Okay. So we have a motion to go in camera and review a record. All in favor, say aye.
Aye.
Okay, we're in camera. We'll just zip into that room right there.
Okay.
Did someone second that? I didn't write it down.
Yes, Nova did.
Okay.
Second it.
Just sneak it out.
Just stay here. We'll be right back.
All right.
I know, but. It's the same
Jim, would you watch everyone's laptop for us?
No, so I just did. Do you know very well what she was gonna be upset about? We have to play stupid a lot too. You just don't. you just feel it's been interesting because I'm like, well, yeah, it's like those. Noise.
Okay. We're back in session and we're in deliberation. Are you running out of power?
Okay.
Because she hasn't eaten.
Okay.
Okay, so there are 3 documents that we're looking at, right?
Yes.
Yes.
And based on this, just to. Nova, will you just clarify what we're calling which? So,
Yes, so it's number 1 had the draft,
there was a Word document.
yes.
Yes.
Attached to it.
Okay,
Number 2 also had an attachment, had a,
it was a PDF.
it was a PDF, and then 3 also had a PDF.
Okay.
And we have them marked, so Rebecca can provide that to the respondent.
Oh, okay.
Yes.
All right. Okay.
I was just trying to pull it up.
Go to,
So shall I, just to hurry this along, shall I do a motion?
if you want to, or I could.
Oh, okay. You ready to do it? Okay, good.
Motion to, okay, see, number 1, in-camera record. Motion to, how would you say it?
Provide the
To
record.
grant the appeal?
Provide, to grant the appeal. Redact the to and from, that would be in accordance with 301 N I. And then on that same document, deny the appeal on the attachment in accordance with 305-22. I make a motion for that.
So is that for the first one?
That's for
Grant
the first one, yes.
What was this?
to
the
grant the
citation.
appeal, redact the to and from per 63G2 301. NI, what was it?
And I, to remove the private information.
Now, is this the Word document one?
This is the draft,
Oh, okay,
yes.
yeah.
So
That's the Word document,
provide the
okay.
email, the email, but not the draft.
But not the draft, right?
Yes. Did we want to rule on each one of them separately? Or do you want to make them
No,
all
I think we
together?
can
we
do them
can
all
do it.
together.
Okay. Number 2, record. Same thing, the verbiage to redact the to and from on the email in accordance with 301 NI, it's private information. And then to release the attachment, it's public. I don't have a thing for that one.
That was the.
301, yeah, that one was, that one was the report, that was this one, it had the attachment,
Okay.
that's public information, under 301. 301.
Yeah, I would just put it under 301, 63G2 301.
Uh-huh. You know what? 302. I am sorry, Rebecca. The to and from is 302. It's not
Okay.
301.
I'm so confused.
Yeah, I'm sorry.
And I, right?
Yeah. And then the third record, same thing, the to and from redacted. And then the attachment is public.
So we're all, I have down that all three of them are,
Okay.
have the same citations.
Yes. Except for the
Except the
draft.
first one has
Except for-
30522.
Right.
Okay.
Okay, Rebecca, can you read it back?
Yeah. All right, to grant the appeal for the first one, it is a draft, to redact the to and from per 302 NI. And to not provide the attachment because it is a draft per 30522. For the second one, to grant the second one and redact to and from for 302 NI and release the attachment, it is public. And the third one, same thing, redact the to and from and release the attachment.
Yes. Okay, so we have a motion by Nova. Do we have a second?
I'll second it.
And a second from Tom. Any discussion to the motion? Hearing none, we will take a roll call vote. Mark?
Aye.
Tom?
Aye.
Marie?
Aye.
I vote aye. And Nova?
I vote aye, but I do have concerns about, and we've been discussing this all day about personal devices and accessing records, government records off of there. I just have to say from my stance that something needs to be done about it.
Yeah.
It's throwing a wrench in everything.
It comes before us all the time.
It does, and it's really difficult for us to make decisions on this.
This is somewhat unique because they found, but they wanted instruction as to whether or not to release it, so.
Right.
So I think it's important to say that we're not necessarily supporting the searching of personal emails.
Right.
Yeah, I think that's a good thing to
Good comment.
mention.
Thank you. So the motion carries unanimously. We'd like to thank the parties for their patience, and the order will be drafted and can be appealed. Dated order. Thank you. Okay, break for lunch, team.
Okay.
Thank you.
You're welcome.
No,
No.
this.
Chair, how long do you want to break for lunch so I can tell the next?
Oh, I knew you were. In session, and so the next item on our agenda is Aaron, is it Pacini?
Correct.
In Jordan School District, it's hearing 2021-138, and Mr. Pacini is requesting a fee waiver and access to records related to the Community Council 2021-2022 election. And how the hearing proceeds is the requester has 20 minutes and then the petitioner has 20 minutes. There's time in there for the committee to ask questions or ask for clarification, and then you're allowed 5 minutes to sum. So, can everybody hear okay?
You said 5 minutes to what?
To sum up.
Sum up. Okay, thank you.
So we will start with Mr. Pacini. Go ahead.
Thank you very much. I think the way I'm going to proceed is probably a little bit out of order from the grandma request, but it might make things a little bit more efficient. I'm going to start with the fee waiver because some of the statutory language, I think, is going to earn support as we go through some of the documents that I've requested. As to the waiver, the first thing is that there was really no initial decision. The waiver was never mentioned in the original response to my grandma request or to the appeal to the superintendent, Dr. Godfrey. So to a great extent, I would argue that certainly appears to be some sort of a waiver of the waiver where they have not actually denied it until I think just recently. But getting into the statutory language of 63 G2 203, the language says that a governmental entity may fulfill a record request without charge and is encouraged to do so. And I'll talk about that in a moment. So if it determines that releasing the record primarily benefits the public rather than a person, that's A, and B, the individual requesting the record is the subject of the record or an individual specified in the subsection 63 G2 2021 or 2. And that's really, for at least for my purposes, family members. First of all, there's no doubt that particular to both my request number 4 and 5, that I refer to members of my family and myself as these communications were produced. So that would certainly meet under B of 203 4B. And it also, as we get going through this hearing, the release of the records would primarily benefit the public. As you already indicated, and I apologize, you're very, very small on my screen, so I can't see who is who. So I apologize, but whoever just spoke had noted that this is about an election, a request for documents resulting from a SCC election, a Student Community Council election. But, you know, what I know has happened, and this may not be appropriate at this time for this hearing, but it would be probably at the next step if this went to court, that there was an employee of the Jordan School District that was at the polling place directing votes, telling people who to vote. And we also know that a teacher at the school was communicating with parents and encouraging their vote because she was in support of the administration, who I was clearly not supportive of. And so part of it is whether or not is that a matter of public interest, and I think the answer there is yes. I also have reason to believe that the ballots to the election just don't add up. If there's been some sort of tampering, I think that's a matter of public interest. Now, this provision, of course, says that the school district is encouraged to do so. That offers a certain level of discretion, but as with just about anything in law where there is discretion, it can't be arbitrary or capricious. And part of the concern here is, what is the school district's methodology or non-arbitrary, non-capricious methodology to deny a waiver, particularly when it involves specifically an individual and his family, with a concern that not just the family, but teachers supportive of the family have been targeted by a school administration. How are they going to objectively deny that when the code encourages them to do so? So there needs to be something more than simply this is what we decided to do. And the two determining factors here are in A and B, whether it primarily benefits the public or whether the individual making the request is subject of the record. There is no C that says, or unless it's going to embarrass the administration or school district. So we need to have something that's more than arbitrary caprice from the school district in making a waiver determination. And perhaps now would be a great time for the school district to explain how that's made and exactly what those numbers are. How many times are waivers granted? How often are they not? And what is the manner in which that discretion is exercised? Lastly, as to the fee waiver, one concern is the code also talks about not charging for reviewing a record to determine whether it is subject to disclosure. There's a question there that I have, and perhaps this committee can answer that. Is it enough for the school district just to say, well, yeah, no, here's the fee, or is there going to be any sort of transparency as to how that fee is calculated? The documents I'm requesting are electronic. They really are not difficult. I've done electronic discovery, and pulling documents with key terms and search words doesn't take that long. So part of the question is how is that number being calculated? I know that the school district has made an argument about the cost. Well, let's be honest, that the district's attorney is going to charge a whole lot more responding to that request than whatever the 200 and what was it, $38.74 that they said it would cost to actually provide these records. And of course, part of the concern, and that's maybe not an issue to talk about right now, but part of the concern would be, okay, once we get those, are we just going to be in another fight? Am I going to pay for documents and we're just going to be, there's going to be another fight over? Does the committee have, before I go on to some of the specific grandma requests, does the committee have any questions on that waiver? Or would they like any clarification before I change gears a little bit?
Questions? No, please go ahead.
Okay, thank you. And if you do, please raise them. The committee has my grandma request, and there was 6 issues here. Given that 4 and 5 were not produced under that, it really tend more towards the fee waiver we just talked about. I don't think there's anything else I need to talk about with regard to 4 or 5 right now. Jumping right in, as I mentioned, there's an issue with this election, with this SCC election. There was an election held on September 10th, finalized on September 10th. The results were tallied and the candidates were informed of whether or not they were selected to this community council. That was September 10th. On September 15th, I submitted my grandma request. And the following day, on September 16th, is when the school or the district or decided to invalidate those results for a number of improprieties in response to concerns that I had about how the process had been handled. This timeline is really important to understand that at the time of my grandma request, everything freeze on September 15th. There was an election. Ballots were cast, ballots were counted, and candidates were informed. But the district takes the rather odd position that there was no election because on September 16th, they magically invalidated those results. Therefore, there was no election that was held through or around September 10th. That is a really, really concerning position for a government entity to take, that they can somehow just invalidate something and thereby stopping the public from accessing what would arguably concerning public records. And so it is not, it is really a spurious argument to say that the school district is taking to say, well, there was only one election and that wasn't it, because they invalidated it. An invalid election, invalid is an adjective and it modifies the word election. There's still an election. And when you look at my specific language, I parenthetically say, regardless of whether the results are valid. And that's important. It's very clear what I was seeking, and I'm entitled, the public is entitled to those results. Now, we can go through these specifically. The total number of ballots cast shouldn't be an issue. The total number of votes for each candidate, the name of those that cast ballots or voted. I am not asking to know who voted for who. That was never my intention, and that is not what I asked for. And then the names and addresses of everyone on the voting list. And please understand that last one was because teachers were sending out emails or otherwise communicating with parents regarding the election. If teachers are going to have access to those for purposes of the election, so should candidates and other parents. Now, the school district has taken the position that this is supposed to be a secret ballot, so I'm not entitled to this information. And that just doesn't make a lot of sense. Again, I'm not requesting the individual ballots of individual voters. I'm not asking to know who voted for who. That's the secret part. And that is important to every election within our form of government. Whether it's at the federal level or state level, we're not supposed to know who voted for who. But they take that beyond that simple privacy to voting results and extend it to everything. And I've listed, and I understand that some of what I list in the support that I listed doesn't necessarily apply to the SCC election. But what it shows is that very, very clearly on the state level, that's not really considered secret information. that the information that the voter rolls and whatnot, that's public information. And that's just to simply show that the district's argument is untenable. Now, as to the last one, I'm going to jump around just a little bit here. The last one, the number of students in each South Jordan Elementary class from each Dibbles category. This is a rather interesting one because in the original response and then also in the appeal from the superintendent, Dr. Godfrey, no one ever said anything about Dibbles not existing anymore, not being available. That was something that was submitted later. So I have some concern about that. Generally, if you don't have something, you say it up front, say, no, this just isn't available. But instead, they do provide some data. I think it was some Acadians data. To the extent that Dibbles in their mind was equates to the Acadians data, I think it's fair that they continue the production. And what that is we need what I've requested is the data for each class, not each grade, each class. The district is arguing, well, there's all these privacy concerns because you're going to be able to ferret out who above benchmark, middle and below benchmark. And that's just not the case. Any given class is going to have kids above benchmark, at the benchmark or below the benchmark. And so unless we're actually going to start profiling or stereotyping students, there's going to be no way to know if any given student is above, at, or below that benchmark. And so the privacy concerns that the district has raised simply don't hold. Lastly, the names of each SCC member, including parents and teachers, the beginning dates of the service and the ending date of their current term. I've received email information over the past months, a little bit at the time on this. The district points this out and says, hey, look, this is what we gave Mr. Piccini. They didn't mention the committee that the last thing they sent was March 9th. It was a very, very tardy response. While I think the day before responses, their own response was due for this hearing. To this point, they've provided some names and documents. I'm happy to see that they provided some screenshots of websites that help us with some of that information. I'm curious though, why particularly, and I put this in my responsive brief, that parent involvement in school community councils, that the schools work in consultation with the administration to set beginning dates and terms of office for school community council members. So it doesn't only impact the school, but also the district in setting these term dates, and somehow these term dates for these particular community councils does not exist. I don't know if they don't exist, but they haven't been provided. And so getting some clarity on the terms and the purpose there is to make sure that the elections are happening as required, that the terms, the limits to terms are being respected. And thus far, I don't know that I've received a complete understanding of those for the timeframes that I've provided. With that, I'll reserve whatever time I have left, maybe for response, but be happy to address anything that the committee would like to ask me.
We do have a question, Tom.
Yeah, so what are you yet to receive that you requested? Make sure I
So I have
understand.
not, yeah, thank you. So under number one, I have not received those. Mr. Van Komen is going to say that I did receive the elections. I received election results that I did not request for the second election, which was held after my grandma request. I have not received any of number one for those election requests that had closed on September 10th, before my grandma request. Two, I'm satisfied with the production on two. I am not appealing that. Three, I would like that information, those emails that show those. I'm appreciative of what the district's provided so far. And if their position is there's nothing else, then that would be helpful that they just say that there is nothing else. I mean, that opens up a whole nother can of worms and issues, but we'll resolve those outside of this hearing. 4 and 5, I have not received anything because they say that goes back to the waiver issue. They say that here's the amount that I need to pay in order to receive those documents. And so those are attached to the waiver issue. And then 6, I've received some summary information, but they are not broken down by classes. They're summary information by grade. And then there are also summary information where it says they'll give me some numbers for maybe above the benchmark and at benchmark, but a range like 10 or more students below this benchmark. But there's no way to know whose class those are, and they're not actually specific numbers. So I'd like a full production on number 6.
Okay, thank you. Any other questions? Okay, if not, we'll go to the respondent.
Hi, good afternoon. My name is Paul Van Coleman. I'm an attorney representing the Jordan School District. This is Superintendent Anthony Godfrey. I'll be asking him for input. You're welcome to also ask him questions during this presentation. I want to begin with the fact that we're here in an educational setting. I wouldn't normally do this, but there are overlays that apply only in the educational context. And grammar recognizes this. It specifically says, for example, if FERPA applies, then FERPA supersedes grammar. So much of what a school district does, they have to do in the context of what does FERPA require? What would FERPA require as they're looking at the specific requests that are made? So that's an overlay. Another overlay, of course, is that the school district responds to the request that was actually made. Not in a form, if they don't have a document, they don't have to create it, they don't have to make other documents. And so those are some big overlays here as we get into this. And I think what I'll do is for example, number 6, there is no DIBELS information. The district went ahead and tried to provide information that it could about something that's sort of similar, and to the level that they were comfortable that they would not violate FERPA. That was, first, they provided it at a school level basis. Mr. Piccini said, I still want to have that information at a class by class basis. As you look at those categories, when you trigger down, if there's personally identifiable information to a student, even if that can be indirect, that can violate the protections. So as you get into each class, you can start identifying students. Some classes, they're not all equal in number, but when you get to specific classes, even if you don't have a specific student, parents may start attributing things to a student, or they can easily figure it out if the sample size is small enough. That's why they went ahead and gave them a sample size of 10. But the real issue here is there are no documents that would be responsive to this. Mr. Piccini continues to ask for more information that the district would not be willing to provide. That's not really at issue here because there are no non-responsive documents. What he's asking for is a claim information. At this point, something he learned because the district came back and said, here is some responsive information that we can give and still comply with FERPA. I know we have limited time. So I think number 6 is really not before this board. There's nothing that we've withheld. There's no information to give. Moving back to the waiver, request number 5, that's really a personal issue. As you've talked about, Mr. Piccini who had concerns with the election process because he wasn't elected in that first vote. There has been only one election result. There may have been multiple votes. There may have been, there were 2 votes, but when the district found out that there were procedural inaccuracies, those were voided. Those were not election results. And so it's also very important as we talk about the request for the specific emails. It does apply to Mr. Piccini and his family, but this is not anything that impacts their rights. The district has looked at that and said, we don't think this is public concern enough, this is not a prohibitory fee. They have a responsibility also to their taxpayers, and they declined that fee waiver. Moving back to number 4, which is included in 5. I think we've addressed that. I'll get into more detail. With regard to number 3, this again is the request was for the names of each SCC member, including parents and teachers, the beginning dates of their service, and the ending date of their current term. Community council elections are governed by statute. It's also very important to note that although the term election is being used, that term is not included in the general election code. So when we start referring to things that apply in elections, such as voter registration and those sorts of things, a school community council election is not an election, and those terms don't apply. Parents don't have to go in and register. They don't give their information so that they can be eligible to vote in a community council. By statute, and that statute is 53G7 1202, and I've given you that. Community councils are governed by those provisions in there. So anything that's talking about an election in general, those just don't apply. And in fact, it does say that the school election is closed, and it's also important, what it says is available to the public is in subsection 2D there. Results of the election held under subsections A and B shall be made available to the public upon request. By statute, it says the results are made available as part of the community council election. It doesn't say that there has to be a voting list, that you have to provide the names of those individuals who applied. This is where FERPA also comes into play, because the district said, well, parents have a reasonable expectation of privacy in certain information. That includes their address, that includes whether or not they voted in a community council election. Parents may tell somebody, yeah, I'm gonna vote in the election, and they don't vote. They may say, I'm not gonna vote, and they do vote. They may tell somebody, yeah, I've got your back, I'm gonna vote. There are a number of reasons why people want to maintain their privacy as to whether or not they even voted. And that's why we have maintained that as a district. It's also important because he says, well, it's just a name and it's just an address. FERPA, again, protects student information. It specifically says that certain information, personally identifiable information pertaining to a student is not public. A parent of a particular student is personally identifiable information. So there are some exceptions. You may say, well, just from your own experience, you may say, well, my student is in the yearbook. My student has a directory. Yes, there is an exception for directory information of students if a parent does not opt out of that. And the provision, every year, notice is given to parents of what is considered directory information. And I should have included this, but this is by policy and it's given. It says Jordan District has designated the following information as directory information: students' names, address, telephone listing, grade, date, and place of birth, participation in officially recognized events and sports, weight and height of members of athletic teams, photograph, dates of attendance, honors and awards, date of graduation, school awarding, graduation credential, title of credential, and most recent school attendance. Nowhere does it say parents' names or parents' addresses. And when you look at the grammar request, again, this wasn't give me a list of directory information for the school. This was, I want to know the parents who voted or who were eligible to vote. Parents, by not being included in this, they have a reasonable expectation of privacy that they have to give information to enroll their kids. They have to say who their kid is, they have to give their address, that. But nowhere does the school say, anybody who asks for that, we're going to give that. By analogy, and I know it's not directly on point, but in the section of code under grammar that says what is public information, with regard to school employees, their business address is public, but not even their home addresses are public. So there's been a lot about, oh, it's only the name of a parent who voted. I'm not asking for their specific vote. Why don't you just give me a list? Again, the school has obligations under FERPA to protect private information. That includes who a student's guardian may be, who their parent may be. That may not always be known by specific individuals. With regard to the school community council names, this is also governed by statute. In the code section that governs the community council, it says, the principal shall enter the names of the council members on the school land trust website on or before October 20th of each year pursuant to this section. So what happens after a community council election is the school principal goes to the school trust land website, which the Utah School Board's a separate governmental entity has record of. They enter the information, and the schools don't keep their own independent records. Those records are then made available. What happened here was, in response to the request, the school realized, oh yeah, we don't keep a record. Let's try to create a table of information that we can get and provide that to Mr. Piccini. That's been provided. It doesn't include the specific date when they began their term. That the district doesn't have a specific record of that, but it has the information that anybody in the public can do. I went ahead and provided that information to Mr. Piccini on March 9th because it wasn't our information. So he complains that we gave that late, but I just wanted to make sure this was the information that the district looked to, not its own record. Yes, it created a record, the table that has been provided to you. They just didn't have access to that specific information that he had. And then with regard to request number 1, again, the election results, I've sort of commingled this, but I think I'd like the superintendent to add a little bit from his experience, including how fees are come up with, because this isn't just something that is arbitrarily picked out. They get, as you can imagine, grammar requests all the time. They have people who have lots of experience with this. People think things, oh, that should be readily available. It only takes this. There is a process to that. There is a process that they go to say, is this really of public concern? Is it unreasonable to not provide a fee waiver? You know, this really stems about, in my opinion, some conflict between the principal, the former principal, who's no longer there at the school, and Mr. Piccini. Superintendent?
But could I interrupt? And if I have to,
Just on a few points.
could I object here?
We don't give.
Hold on, committee, could I make, if Dr. Godfrey gets to testify, am I going to be allowed to cross?
We don't give out parent information generally. There's no circumstance under which we give parent information out to other parents.
I'm sorry, committee. Just
There's
one
also
question. If Dr. Godfrey
There's also a lot that he's
testifies, do I
requested.
get to cross-examine him?
Because we didn't
Thank you.
charge for, we didn't charge for everything on his list. We're only charging for the time-consuming emails that we didn't view to be in the public interest and the things that would take more time. And when you turn over emails, those emails have to be reviewed. You have to read every email to see if anything needs to be redacted. So it may seem like it's just entering a couple of search terms and printing PDF, but there is more involved in that. And it seemed obvious to us that if you mention every one of your family members in a grammar request, that's a personal request rather than more of a public request. No one was, we didn't provide what Mr. Pacini has characterized as election results because no one was elected as a result. There was an election that did have results and we provided that. He didn't ask for that, but we provided it anyway. He asked for Dibbles data, although there's no such thing as Dibbles data from the period he requested. We provided Acadians data as a means to try to get to what he was looking for. But we're cautious about giving scores that where people could even intuit, okay, well, look, this is probably the kid that scored so low. So we're cautious about the privacy of students and parents. I think that's what I'm going to have.
You want to make sure there's some limitations as to, because this isn't cross-examination. This is, you could ask some questions of a witness according to our rules.
So I have one question for the superintendent. Is there a policy? Do you have an internal policy for assessing fees?
There's not a formal policy. We try to be as flexible as we can, but we say, hey, this is going to take some significant time. And we calculate that based on the hourly rate of the people who will be involved. And we have on regular occasion provided a refund if we overestimate that cost.
Can I ask a question?
Yes.
Oh, go ahead. You had one.
I just have one question. If you divided by classroom, what would be the smallest cell size? Would you get down to 1 or 2 students in a cell?
Quite possibly, yes.
Yeah.
Tom?
And this mayor, there was reports there was an election in September, a first go at it, and then it was invalidated and they did the second one on the 16th of September. Is that correct?
I'm sure you're right about those dates, but I don't.
That was the 28th.
Okay.
The 29th, I believe.
Right.
Is there, why was the first election invalidated, or is that something you can talk about?
There were more openings than had originally been communicated.
Okay.
And some procedures hadn't been followed properly. So that was invalidated.
You had to redo the whole thing.
So there were some votes,
Votes were cast, yes.
but it's about, okay. But when you invalidated that, where are the ballots? Were they destroyed or?
I don't know the answer to that question.
The ballots exist, but that was not included in the scope of this.
Sure. So the question I have, and because I think it was brought up, and I don't know if this is true, that unlike in the community council election, you don't have to register as a whatever. Is there a system that allows you to verify that the people who voted actually had the right to vote, that they had students in the district or they were qualified?
There's a form of a check-in of some sort. I don't know the exact procedure that was.
So the little bit of vetting goes on.
Yeah.
That's all I had. Any other questions from the committee? So, Mr. Pacini, can you hear us?
Yes, I apologize. There,
No problem. Do you have any questions for the witness?
Dr. Godfrey, is it correct that you said that, I mean, part of the expense is that, I mean, you search these records and then they need to be reviewed. Did I hear that correctly?
Yes.
And then you said that one of the considerations was the cost to the public.
No. I
So
didn't say that.
the costs of fulfilling a grandma request and denying a waiver has nothing to do with the cost to the public.
No.
Is that the position that is set forth by Mr. Van Komen in his brief to this committee?
Are you
Do you
asking
know?
me about Mr.
Yeah,
Van?
are you aware? Are you aware?
I'm not sure what you're asking, Mr. Pacini.
Well, I'll just proffer that it's not consistent. We'll just leave it at that. One other series of questions. The first election, when the first ballots were cast, that concluded on September 10th, correct?
I don't know that.
Candidates were informed of the results on September 10th. Is that correct?
I'd have to check.
Okay. I submitted my grandma request on September 15th, 5 days later. Is that correct?
I don't have all those dates.
Okay. Are you aware that it was September 16th that the first election, as I refer to it, that ended on September 10th was invalidated, that happened after my grandma request? Can you confirm that?
Well, I think there'd be a difference between when that was decided and when that was announced, and I don't know those dates.
Okay, thank you.
I guess, yeah, sort of to sum up, again, part of it is the district has tried to be forthcoming with what they can, but they have taken a position that they need to protect certain information. Obviously, we're here. We'll submit that. I don't know. Obviously, the district gave the election results, even though that occurred after the September 15th date. That was completed towards the end of September. That was the election result. The district didn't take the position that, well, you gave your request at September 15th, and so somehow we don't have to give you the information. I don't quite understand the distinction that's being made there. The position has been, as the code section talking about school community councils and its election process outside and completely separate from a normal election, that's what the district followed. They have tried to say there are privacy rights. We're piggybacking on the two provisions that are in the brief, the general privacy right and the fact that parents and guardians have to give certain information, their name and their address in order to enroll their students, but that they do so with an expectation of privacy as we've gone through that. If you have other questions, we're happy to answer. I know it's an abbreviated time. Thank you.
Thank you. So Mr. Pacini, back to you, 5 minutes.
Thank you. Mr. Van Coma says he doesn't understand why September 15th is important. I'm going to talk fast because of limited time. Okay, if he says he doesn't understand it, let me explain one more time. Because by September 15th, when I submitted my grandma request, there were valid election results. Now, I don't even think that matters, whether they're valid or invalid, but there were valid election results at the time of my grandma request. Those were not invalidated to September 16th. Now, it doesn't matter because valid or invalid, there was an election, there were results, and I'm entitled to that information. Mr. Van Coma talks about how I don't have a right to the information. We can go back right to grandma, the grandma section that talks about the constitutional right of the public to information. He said, I have no right to this information. In enacting this act, the legislature recognizes two constitutional rights: the public's right of access to information concerning the conduct of the public's business. He says that while it's really for personal use, but then admits that my requests speak to information about me. That's explicit in that waiver context about why you would waive the fees. It's when something's being talked about someone. I asked Mr. Godfrey about the time that it takes to review. He said it takes a lot of time, in which I don't dispute that. But under the statute, 63G 2-203 under fees, subsection 5A, reviewing a record determine whether it's subject to disclosure. That's something a government entity cannot charge a fee for. The districts provided nothing on the fee side to show how this is done, and the information that Dr. Godfrey's provided suggests that they're violating the statute. They're reviewing it and charging for it. That's not okay. Mr. Van Coma wants to talk about addresses and all this stuff. Well, let's talk about the results. Let's talk about the ballots. Let's talk about the numbers. We don't need to muddy it with the addresses. But as much as Mr. Van Coma wants to analogize with teacher records, well, I think the analogy fits when we talk about addresses with other state elections, even if it doesn't squarely fit, as Mr. Van Coma talks about with these SEC elections, doesn't fit within the statute of public elections quite the same. I didn't quite understand Mr. Van Coman's argument about FERPA. He quoted it and it applies to students, and somehow parents now equal students. That information about parents is somehow brought in by FERPA, and he makes that without support, and that doesn't make a lot of sense to me. To the extent that Mr. Van Komen's offered new evidence, I'm going to object to that. I haven't had a chance to look at it. I haven't had a chance to respond to it. I'm also worried about this Dibbles information because Mr. Van Komen's made several proffers. There's been no certification. It's not in the district's answer. It's not in the original grandma answer. It's very easy for someone to come and say, this is what exists and does not exist. Where's the certification that says that's true? Why wasn't included in the original grandma request that said simply there is no Dibbles information? Why not in Dr. Godfrey's response? We don't use Dibbles. Why did they do that? And why is it only now that Mr. Van Komen is making these proffers? That should be very concerning the committee. The idea of FERPA, that somehow we're going to be able to look, even if there was one student in an upper category or middle category or below category, how in the world can we, I think the word was look at a student. We can look at a student and figure out which class they're in, which benchmark level they're in. That is exceptionally offensive, if I heard correctly. We don't profile students. There is no way, even if there's only one student in a section, there's no way to know who that is unless we're going to begin profiling students. There's no way to directly or indirectly even begin to think that FERPA applies, and the district offers absolutely nothing to suggest that the case law supports their interpretation. There's also a question about the SEC member information. He said, Mr. Van Komen said, well, they got it from the trust website. My question is how to get there in the first place. The SEC elections held at the school level. There has to be a transfer from the school to the trust. Where's that communication? I mean, if it was by carrier pigeon, I assume there's not going to be a record. But boy, that would, I have a feeling that it was probably done by email, and it's very concerning that that is not made available. Now, there was some uncertainty about whether these prior ballots from September 10th exist. Mr. Van Komen says they do. Fantastic. Under the statutory rules, they should have provided those ballots to this committee. I can't see those right now, but you can. Prior to this, you should have those in your possession. And my question is if you do. And if you do, take a look at them. If people's names are on them, I'm very happy to redact individual names for individual votes. That's not what I'm after. I am only after how many votes were cast, how many ballots were cast, and who are the votes counted for. Because there's a public concern that there was a problem with this election. Honest to goodness, the idea that I'm not on the SEC did not break me down. I felt an obligation to run where I had raised concerns. I think it's a duty that we're willing to throw ourselves into the fire if we're going to raise concerns, and that's why I ran. Unfortunately, as much as there was an issue that I had with the former principal, the issue continues with the district because there has been a number of arguments that they made that are really concerning about how they not only operate their waivers and their grandma requests, but how they interpret things such as an election. And I think it's very, very, very important that the committee provide these documents, not necessarily even for me, but to set a precedence to let the school district understand what their obligations are. Just the last thing, there's no policy about waivers. By definition, everything they've done then is arbitrary, capricious. There's no possible way, in my mind, the denial waiver that they actually didn't deny in the grandma response and the appeal response. They actually ignored it entirely. But there's no way it stand at this point. And that's one of those things I'd be very happy to take to district court. Thank you.
Thank you. Yeah, 5 minutes.
Just with regard to the waiver, the first response said, if you'd like us to calculate it, go ahead. There's nothing in the code that says you affirmatively have to waive. By the appeal, the actual dollar amount was given, and to somehow say that that we have affirmatively waived the right to a fee waiver when those things were communicated, I think that's basic. The school community council, as I indicated, they log into a web portal. They don't keep records. Again, we're not withholding anything with regard to what we have. You'll see the records that are responsive that we're withholding under the proper classification of private or protected, not public. a lot of what we hear is that Mr. Pacini wants something in a different form, or he wants the district to make certain affirmations, certifications. Those aren't required. In fact, if the district had just not responded whatsoever, we'd be here, and at this point, you'd have the same information. Here's the responsive documents, but along the way, they responded, tried to give what they could. If you have questions, I'm happy, but I'm not going to take any more time.
Superintendent, did you have a?
Yeah,
comment?
just, I feel like we provided most information without charging a fee. We even created some documents to try to be helpful. We gave Acadians data even when Dibble's data had been requested in an attempt to be helpful. And we're asking for the fee for the most in-depth portion of the request. And I was going to mention the information's entered into the website, not emailed to the state. So we made a good faith effort.
Thank you.
Can I ask one question? Once the election was held and the board members have been elected, does that go before the school board to certify or accept or anything like that? There's no formal action the school board needs to take? Okay, thank you.
Any other questions? Any questions? We'll move to deliberation. I do have one clarifying question. It was item number 2 was the rules and procedures governing elections. I didn't see it in the district section.
Oh, I'm sorry,
The second request number
Request number 2, yeah.
Oh, two.
In the initial drama request, it's the rules and procedures governing elections.
I have not challenged that on appeal.
Okay, great, thank you. That's why I didn't see it.
He wanted just some more information.
Okay.
So should we take each
I think we
one
need to.
at a time? I researched this a little bit last night with regard to elections. And I know that they've made the case that this isn't covered under code because it's a school election, but I think it is important to note that even in national elections, individuals can't just go and get voter information. In terms of whether or not you voted, parties can, or a candidate might can have it, but individual people. So, and I think this argument about the students appear in the directory, but not their parents. There is important personal information reported for an individual with regard to parent or guardian that can get pretty complicated. You don't want that out there, right? I assume that's why FERPA covers it that way. So I don't see, I'm supportive of not providing the information that's requested in number 1, except for the total number of ballots and the number of votes for each candidate. There's still this question of the first candidacy, the first election. But, and I don't know if the rest of you have some feelings about that, but.
So I think that's what Mr. Pacini is looking for.
Right.
Is the voided election. He wants those results. I agree with everything that you're talking about as far as personal and private information not being provided. And I looked up the election stuff too.
Yeah.
And I think it's clearly asked regardless of whether the results are valid. And so I think that's what he's looking for. He wants to know what that first voided election was.
And what do we think about that?
Well, let me ask you, do you have record of that? If we wanted to review it, do you have?
You'll have something you can review.
Okay.
For the first election.
First vote.
Yeah,
First vote, yeah.
Thank you.
Like,
Yeah.
so
I might be interested in having that reviewed. Having it reviewed, but that's not, it's not killing me if we don't.
Yeah.
If the majority of you want to go in camera to look at it, I'd be interested in looking.
Well, for me, I'm not sure what the public interest is of knowing that. Unless, I mean, are lots of people upset at school because of this election?
Well, I mean, I think we might be.
The
able to
answer
get
is
an answer.
yes. The
We might
answer
be
is
able to-
absolutely yes, which is why the principal effect.
I think we might be able to get an answer to that question if we saw the first results.
Right.
But that's, again, that's.
Well,
I'm not.
we might want to do that. We might want to look at it at least and say,
They brought something that they could provide as, in case we requested it. So
yeah.
I would make a motion that we go in camera and review it.
Okay, should we continue going?
Yeah, let's
through
do all of them and
six?
Oh, yeah,
decide
okay,
it.
okay,
Yeah.
that's fine. That's, yeah.
So
okay,
that's a
good point.
possibility.
That's a possibility.
Yeah.
Okay, my shopping list here. Okay.
Yeah.
So number 2 is not before us.
Right.
Oh, right. Number 2.
And number 3 is the names of the SCC members and dates of service. And it's my understanding on that one that they created a
Yeah.
record.
I
Yeah.
thought that was here.
To answer the question.
Yeah. In good faith. And I think that's he's going to have to live with that.
Let me ask a question about that, though. It does show 2020, 2021 council members. Is there an updated version of that?
I provided the most recent,
Which is the one
from
that's
the
here?
actual screenshots.
Okay.
Oh, okay.
Yeah, it's
I
later,
included
later in the material.
Oh, okay.
entered after, I think,
Yeah.
that became available on the public website.
I see it. Never mind. Thank you.
So they've attempted to respond to that at least.
4 and 5 are the emails.
The fee waiver issue.
And that, is the fee waiver issue.
They're not denying access to the emails, they're just asking for the fee.
Yeah.
In kind of continuing what we've talked about before, there is work involved in redacting emails for personal information, and there's a cost associated with that.
And there is a Jordan School District policy.
That says
It says that they,
have the right.
yeah. Jordan District policy requires us to charge for time spent compiling a document. It's Jordan District Policy DP 367-12-1. So they've got that built into their process.
Gotcha.
But the information is about him. And so isn't the rule that,
So in their materials, they say we'll start compiling this.
yeah, but they want, doesn't the fee stipulate, say that you don't have to pay the fee if it's about you? Or what is the code on that?
I don't think that's. the-
And that-
No,
am
It
I thinking
encourages-
of
It's
it-
encouraged.
Oh, it encourages.
Yes.
Okay, good. So we have an option on that. Okay.
That's why I
Yeah.
asked about the policy.
And I
Yeah.
don't think
Makes
this
it
one
clear.
falls under releasing the record primarily benefits the public. I don't think this one
No.
is-
I agree with
falls
you on
into
that.
that
No,
I agree.
it doesn't.
at all.
Okay.
I mean, he is a subject of the record.
Also going through the material, didn't think their fee was overly high or exorbitant in any way.
No.
So, at this moment, I would be more in favor of denying the fee waiver.
For that aspect of it, yeah.
And then number 6 is the number of students respond.
It's in that dibbles.
Right. And that, my understanding is that record no longer exists, so they provided a record that's similar, that in a way answers the question.
Yeah, and if I heard him correctly, he wants it by classroom.
Right.
And I know he claims that you can't. But I've done enough research to know that, you get cell sizes below 5 and you know exactly what's going on. And besides that, teachers today are under enough pressure to release information at the class level where he can identify which teacher. That is too much stress, especially now. At least that's my view.
Can I ask a question of the respondent? What's the difference between, if you can do it, so that I understand, Dibbles and Acadians?
Dibbles is the older version of the reading skills assessment test, and Acadians is the new.
More up modern version or updated version? Okay, thank you. I didn't know.
And does the Dibbles though have more categories?
I just don't know about categories
Oh,
as a result of that, yeah.
Because some spells could, you know, you have 3 kids in one class. We need to figure out what's going on. So, yeah, I like that. I like to support you on what you're saying there. This is
And-
probably sufficient.
I've been sensitive to that as, you know, the only female in a department for many years. There were a lot of surveys I did not answer.
I put I was other
Yeah.
because I was the only female.
Because there was no confidentiality at all, anyway.
So we've gone through all 6, right?
Yeah,
And
so
go
the
back
only-
to your,
Well, I mean, that's, yeah, I think we could answer the question we might have as to why that's being requested if we look at the record. So I would say go in camera to review that particular record of the results of the first voting, called an election. But it's up to you guys.
You have that record with you? Do you?
They have something they can provide.
Yeah, I'll second the vote. I think it would be important to see it.
so we have a motion before us from Tom to go in camera and review the one record. And a second from Marie. All in favor? Unanimous. So do you have the record or do we? need
Looks
to
like
get
he's
from
got
Mr.
it right there.
Redcom?
Oh, okay, so something we can physically take and look at. Okay. Hey, well, one of you. Nobody, will you bring your laptop in?
Me?
Yeah.
Sure.
How are you staying?
No.
No, I mean staying here.
You're not, you're coming in.
Okay.
That's what other.
Just finishing out an email.
That they've sent you, said they don't want. That's. Nice socks, by the way.
I know.
Well done, sir.
I went with the green and mine everything.
I was looking
at your Mountain Dew once.
I had the green tie. I was fortunate that I could find that.
Yeah,
I realized that I never wear green.
I have 2 ties.
I was watching this morning, every time they said Paul, I'm like, they're not supposed to be talking to me.
I know, it's like, hey, he looks like a Paul. It's gotta be an attorney.
Get that, everything.
Giving him everything except for general access. I'm trying to keep all the doors that would be included. But maybe we'll just create all doors. I could see that.
Everyone who's filled out this form. There was something here, just I know everyone should have that kind of access.
Or just let them come to us.
Well, yeah.
Just, okay, you need access over here.
Yeah.
Go form, verify, okay, yes, it's fine. There you go.
See, that's why I have to run back and forth to see, this form that I received over here. If it has annex, I'll have to go back and go add that in. That's why I want that software on here. Just like full.
Yes, yes.
Who?
That's gonna be Brandon,
Brandon.
the guy who's,
Oh, okay.
doing the training.
Yeah, okay.
Yeah, I was gonna get mine, I was gonna make sure you got whatever you need on. On that machine.
I don't know.
Whatever machine they want for D.
Whatever I'm gonna need it though, because I'm only a temporary
Oh.
receptionist. And, soon, like, other positions will be opening up. So I don't know.
You have an expiration date on it?
I think it's a year kind of thing.
So I guess that's 10 and then they'll decide your
I have to interview.
apply it.
And he's gonna make an office. But I know Sarah Ball. She's wanting me to do this other position that requires because the legislature just passed a bill about water conservation.
Yeah, so whatever we're showing here might be for nothing. But I was like, I'll teach everything you want to know. You remember that?
Yeah, so I was kind of iffy about it.
Did you see? Install this. By statute, such as it is. So I can read it properly.
I'd be curious to see what your document is dated.
Probably won't even have those dates.
I probably highlighted it for you.
Remember this way, there's only 4 statutes.
Too funny.
Okay, we're back in open session. Recordings are going. And back to deliberation. So after reviewing the document.
Chairman, I'd like to make a motion, but I need to make sure my statutes are correct here. Need to do this much. So I move that we deny the petitioner's request for request number 1 using 2 statutes, 302(2)D in the code, which is again for private protected records, calls this otherwise records containing individuals that disclose of which disclose constitute a clearly unwarranted invasion of personal privacy, in this case names, and also 305(22), and as much as that this is a draft, seeing it was not it was part of a report but not a certified document. And it's a draft unless otherwise classified as public, which it was not. Okay. So we have a motion from Tom. Do we have a second?
A second.
And a second from Nova. Let me just ask the committee, do we want to do separate motions for each part?
I think we need to do a separate one, at least for this one,
Okay.
because I don't know how we do it. It'd be easiest to.
I think so.
Yeah.
It'd be the most clear. Okay. So is there any discussion to the motion? Hearing none, we'll take a roll call vote. Nova?
Aye.
I vote aye. Marie?
Aye.
Tom? Aye. And Mark?
Aye.
That motion carries unanimously. So now on to item number 2 is not before us because that's the rules and the procedures governing elections.
Yeah, you got that.
So on to number 3, the names of the SEC members and dates of service. Any discussion to that?
I thought that had been provided based on what.
That was this one here.
So I would make a motion to deny request number 3 that is for the names of SCC members and dates of service. And because the record has been provided.
I'll second that.
And a second from Marie. Any discussion to that motion? Hearing none, we'll do a roll call vote. Nova?
Aye.
Marie?
Aye.
Tom? Aye. Mark?
Aye.
And I vote aye. The voting is unanimous. And now on to 4 and 5, and those are the emails.
So this is the fee waiver one, right?
Right.
Right.
Well, I just want to point out that in terms of giving it, waiving the fee because it's about the individual, is encouraged but not mandatory. I think, and also as I read the statute in this, that it's not clear that this is of public interest. I'm sure that Mr. Pacini is concerned about some things, but I am comfortable with the small fee that he's asking. And as I said earlier today, we just cannot, we have to pay for them somehow. We need people to step up and pay for it. So would deny the fee waiver. My motion is to defy the fee waiver
For 4 and 5.
for 4 and 5, yeah.
So I will second that motion and just say that I was impressed with the way the district responded to that part of the request. And they laid out their fees, the reason for the fee. And I also don't think it's too high. So that's my second. Any discussion to the motion? So hearing none, we'll take a roll call vote. Nova?
Aye.
Tom? Aye. Mark?
I,
Mark votes aye. Marie?
Aye.
And I vote aye. So that motion carries unanimously. And number 6. Oh, you say something?
no, I was just gonna say, I just have a hard time with the fee waivers and in my own mind, working out when it's justified and when it's not. So I don't think there was the public interest that there was with the fee waivers we did earlier today. And the other criteria about it. That's why I hesitated, because I'm just unsure.
I do think that's the distinction though.
Yeah.
That's our option, really. So appreciate that, Mark. Chair, on number 6, I'm not sure how to craft this motion here, but I would say I would deny the request because the record does not exist as requested. So I guess that, the district does not, the record does not exist and they are not compelled to create a record for information they don't have. So I would deny it based on the fact the record doesn't exist.
Second.
So we have a motion from Tom to deny. Well, I don't know, is that, if the record doesn't exist, do we just deny the appeal? To deny the appeal because there is no record. Right.
You can't grant it because it doesn't exist, so therefore it's a denial.
Okay. And so we have a motion by Tom, second by Mark. Any discussion to the motion? Okay, so we'll start with Nova.
Aye.
I vote aye. Marie?
Aye.
Tom? Aye. Mark?
Aye.
So the voting again is unanimous. So all of the orders will be reviewed and signed by the chair and then distributed by the executive secretary to all the parties within 7 business days. Either party may appeal to the district court within 30 days of the date on the order. I'd like to thank you all for your time.
Thank you.
Thank you.
Thank you.
Committee, we have one item left on the agenda, and that's Paul.
With education.
You're right.
3 out of 4.
What was that? We're gonna talk about legislation. Paul, do you have your report?
I've got it.
I'm concerned that this thing is soulless in this.
If your stuff's in Latin, that's well before this.
Poor Rebecca, she gave me so much crap.
What's the date?
What?
I said, this is in Latin, it's.
What's the date on it?
What's the date on it?
Yeah, it's, to be honest with you, it's like July of 2016 or something.
See?
It's not July 2016, is it?
Okay, Paul, give us your highlights.
Oh, boy. Okay, so here's highlights. I'll give you the whole report.
No, the whole report's a highlight.
Oh, it is? Yeah.
It's story time.
Story time. Oh, Benion's case. He's just doing all those kind of sad things where you just kind of wish that someone actually had an attorney representing him. He filed his complaint. He didn't file it right. He didn't put the parties in there. He had parties in the header. He didn't have parties in the body of it. And now he filed, I just got an email from Mike O'Brien. He's like, I don't see anything happening in the case. I'm like, I'm about ready to report on this to the State Records Committee. And I actually put the motion down exactly. Motion for service and acceptance of the parties of an amended complaint and petition. I have no idea what that means. What he's trying to do is have an amended complaint and petition, but it's a motion for service and acceptance. And you just, I wish he had an
Paul, I thought
attorney.
he had an attorney.
It's funny, he always puts that it was reviewed by an attorney and he puts that on there, but I don't think it is. So, because he did the same thing when I was here.
Right.
And the stuff was just all out left field and
Whiteboard that.
it's, the case is just gonna be complicated because I almost think he has the stuff, he doesn't know he has the stuff, and we'll figure it out. Rosenstein versus UDOT, acceptance of service. We have filed an answer on February 22nd for that, dropping down. There we go. Immigration Improvement District, Mark Tracy. Whoa, too far. Motion for summary judgment filed by Immigration Improvement District. So we'll see how that goes from there. Let's see the cross memorandum opposing, all those good things. Stecklo cases. Let me report on this because one is really interesting because Judge Treese, she basically said, let's have a hearing and let's talk about whether or not HB 399 affects these, oh my goodness, what's it called? I was going to say Brandis, Garrity. I like Brandis, how do you Brandis, Garrity. And it's, just, well, we kind of mentioned it during lunch. Did HB 399 really make a difference to the law and what the state records committee? They're going to argue that. I know that the Tribune's going to say, nope, it isn't. You still have the weighing provisions. It's still allowed there.
Isn't there also a time factor there too, seeing as this happened before 399 was passed?
We had that last year, didn't we, Paul, where a case?
This is an interesting question. The BYU case.
Yeah,
Actually,
that's what I'm remembering.
If the legislature goes through and changes, say, this record is now private and it used to be public. If someone made a records request prior to that legislation going through, does that mean it's still a public record? My argument has always been, you go back to Deseret News. Deseret News, you're always continually reevaluating whether or not a record should be released. And if the legislature goes through and says this is a non-public record, that's your reevaluation. The legislature it's important enough that they've changed the law to make that. I can say, well, this is a public record issue. You got in before the wire. That doesn't seem right, as an archivist soul would have. I mean, you do it based upon what's the classification at the time the record's being handed over or something like that. So,
And in Garrity, in this case, like I would assume all the legislation did was added some clarity. That's all it did.
It depends on which legislator you talk to.
Right.
Some legislators say, we have now just taken all those Garrity statements and they're now non-public and you can't get to them, and it's not what the legislation says.
What it did
Underground.
do was make it a little more challenging for people who want to go after those records, because now they're
Yes.
saying, oh, we may go to the SRC, then we may have to go to court. It's going to cost us money.
It might make it a little more difficult, but it does not make them completely off the board.
It's a hurdle, but it didn't take away the track.
In fact, a lot of those statements are given out consistently.
Well, when we had the arguments made before us, we only had 6 that came here. All the rest gave them over and said, here you go.
Yeah, but the difference was, remember, that the people who voted to release it did so because there was nothing specific in the code to tell them what to do. So now there's a specific statement. And that might be enough to put more people unwilling to
Yes, I say it's
release.
going to dissuade them from pursuing it.
Yeah.
It would make it harder, definitely.
It won't dissuade some media people though. I mean,
No, I'm
the
not
big
talking
boys.
about the people who come before us. I'm talking about the votes on the committee.
Oh, I see what you're saying.
Because as I've talked to everybody, the people who voted to release it said, well, there wasn't a statement at all, and now there is a statement.
Yeah.
Missed that day.
So Salt Lake Tribune, Deseret News.
And they'll still chase it.
Still.
Sure.
Yeah.
I wasn't here that day, so I didn't get to see that.
Okay, Cantwell versus Utah, second amended scheduling order. Just filed on February 18th. And then we're gonna drop down lots of asterisks because nothing's happened on those cases. All the way down to Sherrod versus Utah Board of Pardons. Motion dismissed was filed by the state of Utah. I've got to read through that. I didn't realize that came through. I think that was one of the court kind of put notice out, by the way, here it is. But the problem is often you just get it based on a case number. You don't see the case name. So I'm gonna take a look at that and see, just make sure that that motion to dismiss is gonna be able to cover us, because I'd hate to have everyone else get dismissed out, the other 8 parties, and we're the only ones left. I don't want to do that, no. Platt versus Utah Attorney General's Office, 3-day trial, set to be in person, May 10th through the 12th. Paul Amon versus Utah Attorney General's Office, that one's gonna be a trial as well. Pretrial conference set up for April 7th. We drop down to our appellate cases. Next page there. And Big Game Forever, they're just kind of going through the briefing. Stephen Isco, he lost before the Court of Appeals, you remember before, so he's filed a writ of certiorari with the Supreme Court. Next one down, motion for reconsideration filed by him and a second amended motion to stay proceedings for seeking an appeal interlocutory order. Probably not going to be granted. Immigration Improvement District, we have a scheduling order, but we're going to be, hopefully those cases will be wrapped up. Immigration Improvement District, I think probably just from when we met, and poor Rosemary, I feel sorry for her. She's been brought into that case. Stephen Isco probably has received all the records, and he just doesn't know he's received all the records. Hopefully with Rosemary coming in, she'll be able to sort things out and be able to convince Steve, yes, you did receive all the records.
And then you would just withdraw.
And then hopefully dismiss the appeal, but who knows? Who knows? But the DEQ case will come up and we'll have a hearing on that, and it should be finalized maybe in a couple months. So the UNESCO cases, in a way, they're kind of starting to wind down. So as amazing as that sounds. And drop a little bit further, since we had the request. You can see the likeness between the two. Now I'm not in my Jungle Cruise costume there. This is in front of Big Thunder Mountain, and I would have been 19 at this point. But the fact that they would go ahead and go forward, do a movie on the Jungle Cruise and cast The Rock as me, I thought that was great, because you can tell, just looking at those two, how close. And yeah,
I was thinking the guy that really.
Send me that.
I thought the guy in the back that's really skinny and anorexic was the one you were pointing to.
no.
That's a great picture.
That's a great picture.
So I don't know why I never got a picture of me in the Jungle Cruise costume, because at least at the end of that summer, I was just about ready to leave on my mission. So I'm like, oh, let me get some pictures. So I got some pictures on the Jungle Cruise, and some people I knew, then got some pictures of me in front of Big Thunder Mountain, because I was working Big Thunder Mountain that day. But when you're doing attractions, you're kind of assigned to Frontierland, Adventureland area. So I had they start you out on Jungle Cruise, see if you can make it, and then you can do shooting arcade. I did that for part of a summer. That's how I got to be a good shot, I guess.
So wait a minute. You worked there?
Yes, that's
So-
me working there at
This
Disneyland.
wasn't your first Mickey Mouse operation.
No, I've had a lot of experience in Mickey Mouse.
Set up for that one.
Mickey Mouse signed my
That's why you did so
paychecks,
well.
yes. So that's what, and so Rebecca's like, how much was about yourself? Because I usually kind of have it at the beginning, just like, here's what I've done. And this time I said, the real reason why they asked me to come is not because I've been representing the State Records Committee or that was a history major. No, it's because I'm funny, because I worked at Disneyland. Make it interesting. Archive's interesting. Why not? That's fun. Oh, and so the personal privilege, best gift ever. So to say thank you, they got me coasters, and they have from yearbooks of, so 65 World Series on this one. This is from the Dodgers 1966 yearbook cover.
I know you well.
This would have been a scorecard from 1971, it looks like. And then this one from the 1981 yearbook. And the fun thing is on these, I have these two.
Really?
So I actually have them, the World Series. I got it from my brother, 1965 World Series, and then 81. I mean, I was 12 and I got my yearbook from Dodger Stadium.
Nobody doesn't recall the 65 World Series.
No, I don't.
I don't recall the 65 World Series. I know what happened, but
Yeah.
I was not alive at that point.
I do recall it. I was 12. Don't embarrass me.
So that's what I got for speaking today for archives. They got me the
Nice.
nice coasters there. So
I got this badge
And you have to give it back. No, I did get,
I'm a
this
little
badge.
offended, it says Tom's an SOB, that bothers me a lot of bit, but.
I did get this one, so this is good.
It does say that.
It does. It does.
Make sure you're.
SOB. Well, the last thing on the agenda, thank you, Paul, is a legislative update. We talked about the fees bill, or what did you say, Rebecca, taps the brakes on?
That's the term the legislators used. It
Oh,
taps the
Susan.
brakes on voluminous requests or vexatious requests, but it was not a vexatious requester bill. That's what everybody called it on Twitter.
So exactly what is the, and it passed?
Yes, it did.
And what does it say exactly?
I can pull it up. I have it right here.
Is it part of the code?
It is now part of grammar. It's going to be added to 203. And so the new verbiage says, one, that the media, it defines the media representative and says that a media representative does not include a person who requests a record to obtain information for a blog, podcast, social media account, or other means of mass communication generally available to a member of the public.
Really?
I'm very supportive of that.
That was
Really?
added in after the initial language. That's draft number 2 or 3.
Really?
So that was added in.
We
and
should
I'm-
have used it this morning.
The media representative means a person who requests a record or obtain information for a story or report for publication or broadcast to the general public.
So
Wow.
some of the presentations, vexatious would come up and they would talk about vexatious requesters a little bit. Is this the bill that during the presentation, one of the legislators said that they wish
Yes.
this was named vexatious?
So,
And Rebecca was,
yeah, so
Tell me
Renee was
about-
speaking for the Media Coalition and said that they had language, which is this that was added, that they were willing to provide for the legislators. And so Thurston asked if the language of the bill would, as it was, would allow a entity to say that a media organization was vexatious, and she said yes. And Thurston said, I would love to label the Tribune as vexatious. And Twitter exploded.
but then you go to the statistics and this.
The media is not vexatious.
Yeah.
They
Not by comparison, at least. I mean.
Right.
Yeah.
I'm not surprised by that. You know.
I'm surprised by his comment to the media.
Yeah.
I'm not either.
The other addition to 96 says that the first quarter hour staff time spent in responding to a request under 204, a governmental entity is not prevented from charging a fee for the first quarter of an hour of staff time in responding to a request if the person who requested it is not part of the media and previously submitted a request within 10 calendar day period immediately before the date the entity, before the date of the request that the entity is responding to.
Oh, they come up with 10 days. I would put 2
Grandma's
weeks.
not consistent with the calendar days and business days, but most things are 5 or 10. And so I think that's where it came from.
Does that say
It
calendar?
Business, isn't it?
is business. This is
So why
not.
10 calendar.
This is 10 calendar days.
A week and a half. Yeah.
So there was that bill and it passed and we'll see how it's doing. And it was ran by a senator and rep from Cache County.
Yeah, Senator Johnson from Cache County.
But I have a question about that for the media. So if you get an independent journalist in here who has published and, reputable, do we take that person as a media person then?
For example,
As what?
like Stecklow, he was kind of freelancing on
Yeah.
the
Yeah.
side.
He is, but when he appeals, he's usually with the Tribune and Frontline.
Oh,
He's
okay.
not,
What about Eric Peterson?
he's the Utah
He'd be okay too,
investigative
that
journalism.
I think he probably would pass the smelling test on that.
Tribune.
But if you've got somebody who says, as an example, I have a blog that's followed by 35,000 people around the country, but you're not an established journalist working for a certified newspaper or publication, yeah, that's not enough.
Yeah.
I was thinking a blog of like 10.
Yeah, but you know,
Look, I'm a journalist. I got 10 people following my blog.
yeah, doesn't make you a journalist.
No.
I sleep in my car. I'm, in my garage, I'm not a car. That happens. That's that same thing.
This is one we'll watch how it and follow up with.
Well,
especially
there'll be
Cache
some,
County.
there'll be some discretionary calls that we may have to make or that have to be made along those lines.
So we'll see.
It's like,
It was encouraging, though, that they're starting to talk about vexatious
Yeah.
requesters and what does that mean?
yeah, it's pertinent to this group, absolutely.
I was given some language from the media coalition. And I think people are taking a real.
That's why-
honest
Other
look at
states
this.
have
They're trying
language
to be
about
more-
vexatious requesters and their record access laws.
Yeah, and I think the
the
media
language-
people don't want to be categorized as the same as somebody who's just sending grammar requests all the time. You know what I mean?
The language suggests that we would have the authority to declare someone vexatious in a hearing.
So let me ask you, if somebody came before you, now, if you get a request from somebody, an appeal from someone who wants information that would be normally disclosed to a journalist, I mean, do you vet them at all? How do you know?
There are very few things that allow me to deny an appeal. That is not one of
So I
them.
was thinking. So it would have to come here and we would.
Yes, you guys get to decide that. Yeah, not me.
The only time we kick it out, it would be.
Heard it before,
heard
it's
it before,
untimely.
Same normal entity, same record series, don't have the record,
Yeah.
and then,
Don't have jurisdiction,
cases where
it's
they
the
just don't.
courts.
Yeah.
We're still waiting for the CAO to answer.
Because they missed the 30 days, or in some cases, they just never complete their appeal.
You probably didn't know this, but how many times do you get appeals because somebody has appealed to get a record and the respondent says, we don't have that record, and they still want to come before us thinking, well, we know they have that record.
Yeah, we get those pretty regularly.
Our administrative rule actually throws the burden back on the petitioner to say, tell us why you think they have the record.
Those get reviewed by the chair and another person on the committee to see if the chair thinks that there is enough evidence that a record should exist, to see if it's worth hearing.
Because we had that one just a couple months ago, we shut down because there was no record. Yeah.
One thing that happens though, with multi-part requests, if one part of the request is for records that don't exist, but something else is for something that was denied, it comes to us anyway and you usually hear the whole thing.
That's what happened today.
Yeah.
We're hearing
Yeah.
These multi-part requests.
Like number 6.
Yeah.
And a good way to just kind of think about it is that if they don't have the record, how can we order them to give a record? We can't. We're not a court. If they want to go to a court and get an order, we've given them the pathway. Here's the denial. You
Can a
go.
court make them produce a record even though we can't?
Court can do whatever they want.
Okay, there you go.
I think the phrase I use, there's nothing like God on earth as a federal judge in his own courtroom. I mean,
Then they can send police,
they can say, yeah, they have police powers behind them, contempt and
which
everything.
we can't.
How cool would that be?
Yeah, there's a big difference between us and the court. And sometimes I chirp often and every once in a while, that's one of the things I just have to say, we're statutorily defined, courts are not.
So a couple other things that passed you might be interested in. One was HB 123 called use of force revisions. Actually, I think it might have gotten renamed. But this one requires officer involved incidents. The investigations have to be done within 180 days. And the results posted online subject to grandma.
Wow. That might keep a few-
So that's HB 123. And then HB 260 on law enforcement recordings requires that law enforcement recordings be released within, it said 120 and then they changed it to 10. Within 10 days of an officer involved critical incident, provided certain circumstances are met. And so more recordings are going to be posted as well. Then an OPMA bill passed. So if anybody attends online, then the chair has to poll the vote, which we do anyway. And you can't have somebody sit in for you when you're attending online. Sorry, you need to come to the meeting. No one can vote proxy for you. Don't send your kid to say, I vote aye.
That weekend at Bernie's things I had planned.
Gone do proxy votes.
I've noticed Nova's been sending her kids in. to deliver her vote.
Come out of class, come home.
And then there are a couple things added to 305. And so Just update your copy of grandma if you use a paper
We'll
version.
bring new copies.
We'll bring you copies of grandma.
So do all those things fit under 305 or?
There was one thing added to 302. There was another private record thing added. And let's see, this definition of security measures was updated and something was, and that they added something to protected records.
Wasn't there also, Rebecca, for water? Like water system plans,
Yes.
dams. and that.
Oh, yeah,
They're not considered records underground.
the
They're
protected
kind of.
private or not. or-
They're not even underground, right? They have their own statute.
Isn't that
Oh.
106, not part of ground?
Oh,
They call them that.
I like security plans.
The one, Rebecca, what was the number for the cell phone or personal device that didn't go, that bill didn't go anywhere? Was it 56?
Yeah. You referred to.
Yeah.
HB 57 was, Stoddard was the sponsor. That one defined electronic records and was supposed to clarify access to records on a personal device. But I think the language was the opposite of what the sponsor wanted, so it died pretty fast.
There might have been a meeting with this sponsor at some point.
Well,
It was basically that if someone has government records on their personal device, the record officer can ask you if you have any and to provide them, and that's it.
So you can say no?
and it
Right.
said, didn't it say that their statement of whether they have it or not is conclusive?
Yes,
Was that-
conclusive evidence of, and that was not gonna fly.
Yeah. Wow.
No,
So we-
I have nothing at all. Okay, well, can't do anything.
All
Sorry.
right, take your word for it. So
That's
that
just an
bill didn't-
invitation to do whatever you
Well, it
want.
didn't even get a co-sponsor, so it just didn't even make it pass.
I've told you this story before, but when this started coming out, I remember covering a certain city council meeting in this county, which will remain unnamed. And you could watch the council people. One guy was doing this and I was watching, the second guy over here was laughing. And you know, they were texting during the meeting on their personal phones, maybe about the speaker, maybe about the reporter who was sitting there looking at, I don't know, whatever. But you know, that went on, that happened. And I remember telling the mayor at the time, you realize I could request all those emails because they were doing it in here. I would have been wrong because I probably couldn't have gotten them because they were on their private phones, but they used to happen all the time.
Still
It's-
happens.
Probably does.
And that was the Allen case.
Oh, is that the one in Utah
Wasn't very
County? Was the one with Bredoville
that was
Falls?
the
That's
other
it,
case,
yeah.
yeah.
Yeah, Alan's, it wasn't during the meeting, but I mean,
Yeah.
he's-
Yeah.
you know, why I want text between him and developers. It's not because he's just a private citizen, it's because he's a commissioner.
Yeah. That one proved to be interesting.
But we
There was
couldn't
another
order
bill
it.
that failed that would add 2 members to the committee, someone from county, someone from law enforcement.
That
And
one,
then-
Rebecca, I want to follow up on, but it was drafted by Cache County.
Cache
Senator.
County.
So I'm, just a theory that they think that the fee bill fixes that issue. Or adding 2 more members was in response to the Garrity issue. I'm not sure. I'd like to follow up and see why they think we need 2 more members. Because it was law enforcement.
In the counties,
And county.
someone from the Utah Association of Counties.
I'm sure that Jeff and Michael didn't want another law enforcement person on the committee, did they?
Yeah, we used to have, well, no, it was an elected official, right? That's when we had a sheriff.
The sheriff out of Morgan.
Yeah,
Because we couldn't find any elected officials willing to serve. I mean, we had the county auditor at one point
Yeah.
for Salt Lake County.
I think if we get 2 more people on the committee, it should be a lot easier to have a second meeting once in a while. Because
We only need
we only,
5.
as long as the size of a quorum doesn't change.
Yeah, they left it at 5.
Four.
Really?
Five.
If it had 9?
Yeah.
Wow.
So that would have given us some flexibility.
Yeah.
Yeah.
But imagine 9 of you trying to talk at the same time. It's just
That'd
unwieldy.
be too many. if
They
we
could
get
call
that
us the
many people on the
Supremes.
committee.
We call it the Supremes.
The grandma supreme.
You're on the SRC, was that the Supreme Records Committee? What are you talking about?
So I want to just know where that bill was coming from and what
I don't know.
You know, the folks out there, what they thought.
Here's what's amusing about that. It takes them forever and a day to get 7 people approved because they drag their feet for months and months and months on, I mean, we heard about you in like August or September. So can you imagine if they say, oh, you got to appoint 2 more? And we'll get to that, you know, during the vernal equinox or something.
And that was, Novus was record speed.
We actually was. We were 6 for a long time. We were 5 for a while. Yeah.
There was one other that I feel like I just want to, in my own defense, when this meeting was getting organized and I was asked if people could provide public comment, HB 135 was in the works. And that was, it's an OPMA bill that would require the public to be given time to comment during a public meeting. So that one did not pass.
Who could comment during a public meeting?
Public.
The public.
Oh, the public.
You must provide time for the public to comment in a
But
public
you,
meeting.
you can limit what that time is though. I mean, like Bountiful allows 10 minutes in the city council and I think Woods Cross, I mean, West Jordan allows 20. You could say, okay, we can allow 2 minutes of public comment for 3 of you like you did today, or none.
I will leave it up to the chair. I just tell people, I will let the chair know that you want to comment.
You know, the thing about public comment though, what's interesting about that is when you go into a government meeting, like a city council or whatever, there could be a valid reason. Usually they don't complain about what's on the agenda. It's something else. And, you know, I don't know that public comments in this kind of a setting is appropriate even.
I'm going to say I agree, and what your statute actually says, at the hearing, the State Records Committee shall allow the parties to testify, present evidence, comment on the issues. The committee may allow other interested persons to comment on the issues. Totally discretionary.
I remember before, because I talked to you about, it, I was like, why are we having public comments? Because I was always told no.
Well, we just found they don't.
I never told you no.
You know, I
I
agree
got in trouble because I had
on
public
both
comments.
sides. We didn't get much
I
out of
did.
it, but
Just got mad.
given who was in the room today, I think we needed to let some people talk because people calmed down over the course of the discussion, if you
Yeah.
noticed it.
Say, here
Yeah.
it is, and that was her.
And if they're saying it face to face, it's a lot different than if they're trying to email you, because they'll say things to you and they don't have to look at you.
Yeah.
They won't say face to face,
No, I think this morning it was good to have them
Yeah.
here. I do.
except for the tutorial about.
But we shouldn't do it as a
No.
practice.
No.
Hey, by the way, just so you know, it's not that easy to get Texas. Let me just explain how this works to you.
But the thing
Why
that
did she pick me out?
Well, because your
Because I
comment,
said.
you said, how are you
I
going to
asked
do
her to
this?
do it.
And she thought you meant, oh, she doesn't know how to do it.
Here, Marie, let us help you with that.
There's one other bill that didn't pass you might be interested in, that is HB 140. That was called Government Attorney Fee Amendments, which would, Berkman was the sponsor, and it would allow attorney fees to be awarded to the in civil suits. So like a grandma appeal to the district court could have attorney fees, I think is what that was. That did not pass, but that was kind of.
It got Paul's attention.
Did you think overall that the temperature up there was, again, kind of fighting us or not?
Fighting us?
Well, fighting the open records thing overall, like, it's not like it was a few years ago where there were.
No, no.
There's always several bills where
Yeah, I know.
things are, they add things and.
But I do think that government, all government is feeling the weight of, I mean, it's the information age.
Yeah.
And it's just. there's
Well, there are no
more-
secrets.
There's more out there.
Mhm.
And there's
Cameras
the
everywhere.
expectation has changed.
Very much so.
Does anyone actually calculated the cost of grandma? At the, I mean, from the,
This agency hasn't.
No, some people are working on it, trying to get data for a possible vexatious bill, I think, maybe.
We've been collecting it. as
We've
a-
been,
The time we spend on requests.
Well, look at it this way. So the 5 of us met today, $300 each. So that's 1,500 right there. Just kidding, there wasn't $300 each.
Really?
No, but it was what?
She said- Getting paid for, I wanted to say earlier this morning, I said, who's getting paid?
What's been interesting to me is when they will come in to fight about a fee waiver of $100 with an attorney, that they're paying $500 or $600 to come in. You know, we've talked about this before. I just, doesn't make any sense.
$90,000 out of principle, because if they don't do it here, then everyone else will.
90,000 is different than 100.
You haven't let me followers get $1 from each of them.
I wanted to say that. I wanted to say, you know, get organized, charge these people, and they'll be more committed to you if they give you money.
$5.
It was like $5, the fee waiver case for the committee. And I think I even said on the record, I was like, I'm gonna pass a playground. We just, here you
I
go.
remember you telling, I remember that, yeah. Just pay- You want to reach in your pocket
Yeah,
until the
pass around
$5
the
is they
plate,
give the
let's
record.
go pay the $5 and be done. Okay,
Where's
next
the
case.
prisoners?
Probably.
What's that?
I think it was one of the
There
prisoners.
was a prisoner.
That was a prisoner case.
Yeah, I remember that one.
They get that $8 a month. What are they complaining about? Yeah, sometimes you just want to pay the fee for them and let them go. You know, here's your $20. Just
No,
give
our
me the
time, it's worth the $5. Here you go. Go away.
record.
All righty. Thank you, everyone,
Is
for
that
your
it?
time. I think we've got it all. A motion to adjourn the meeting.
Mr. Motion over here on the left.
Mark has made a motion to adjourn. Nova second.
We have a discussion. We have a discussion?
We are adjourned.
Thank you, Mark.
All right,
And let me
Tom,
turn off the
Ken, come
recording
see
on
my
the-
baseball card.
All right.